Prosecutors say this Wisconsin 17-year-old lived in his home with his parents' dead bodies for 2 weeks before he took off on a road trip. The former Student of the Month was arrested in Kansas and just returned back to the Badger State to face a judge. We're on the case presented by Law and Crime. I'm Chris Stewart. We just learned new information about 17-year-old Nikita Casap as he made his first court appearance in Wisconsin. Here he is entering the courtroom in a protective vest in Waukesha, which is about a half hour from Milwaukee. Right now, he is charged with operating a vehicle without consent for allegedly taking his stepfather's VW Atlas without permission, as well as his stepfather's gun. Prosecutors say in the very near future, this teen will face murder charges for what they uncovered on February 28th inside the home where Casap lived. So let's get caught up on this case and then we'll break down what happened in court. On February 28th, the mom of Casap's stepdad, Don Meyer, called police in Wisconsin from her home in Massachusetts, and she asked deputies to do a wellness check at her son's house. She said that she and Meyer's sister received text messages from Donald that they found odd that week. Meyer lived in Waukesha with his wife Tatiana and Nikita Casap. That's Tatiana's 17-year-old son. This picture of the family is from WDJT-TV in Milwaukee. When police entered the house, they found Don Meyer dead. He had a gunshot wound to the back of his head, and Tatiana, Nikita's mom, was also dead. She had a gunshot wound to her torso and one from close range in her neck, which killed her. Who they didn't find in the house, though, was Nikita. The 17-year-old school was also concerned because he hadn't shown up to class for roughly 2 weeks, and a school resource officer also had asked for a wellness check. According to this criminal complaint, that officer cited that Nikita had perfect attendance at that point in the year. He also, Nikita, appeared to be a good student. In December of 2022, he was Student of the Month at Waukesha West High School for the health department. A teacher back then said, quote, "Nick has a great work ethic and does not hesitate to find clarity when needed. He's a strong advocate for his success and works diligently to maintain a high level of rigor. He is very polite and works well both in small and large group settings." So the question at that point for investigators was, where was Nikita? A neighbor told them they had seen Nikita driving away in his stepdad's car. That is a 2018 VW Atlas. It's important to note that Nikita doesn't have a driver's license. Deputies then pinged Tatiana and Don's cell phones, and that showed a location of Cheyenne, Wyoming. That's more than 14 hours away from Waukesha and 984 miles. Eventually, Nikita was arrested all the way in Waukene, Kansas. Police say he was driving his stepdad's Atlas, also had the family's dog in the car, and inside the vehicle as well, police say they saw a Smith & Wesson handgun in plain sight. Specifically a .357 Magnum. It looks like this. The complaint notes that Nikita's stepdad had bought a Smith & Wesson .357 Magnum, and that was missing from the house in Wisconsin.
Why don't you just jump over here real quick? I'll jump right here. That seems a little bit easier. Yeah, right here. Stuff. Can you see yourself good there?
Yeah, I can see myself.
Nikita appeared in this extradition hearing in Kansas, and he was brought back to Wisconsin. And that is where we are at this point. Nikita is in Wisconsin. He has made a court appearance in Waukesha, and during that court appearance, prosecutors laid out some new information as we piece together the timeline of what they believe happened. And at the time of this recording, remember, Casap is only charged with taking a car and a gun without permission. At this point, he is not charged with murder.
And at this time, I would be making an oral motion to dismiss based on my review of the criminal complaint. I do not believe that there is sufficient information within the four corners to support the two charges, specifically with respect to the portion of both counts where there is an allegation that these things happened without consent. There is nothing that I can see other than one sentence at the end that says, based upon information and belief, victim A did not give the defendant permission to operate the VW Atlas, nor did he give consent to remove the Smith & Wesson .357 Magnum, So based on that, I would move to dismiss at this time.
The defense asked for this case to be dismissed, with a key part of it being there's no way to tell whether or not Casap had permission to take the car and the gun because Don Meyer's dead. Here's how the prosecution responded.
We'd ask the court to deny that motion. In this case, what's alleged to have occurred is that the police went to the house the defendant formerly resided at. He is no longer welcome at that residence. His stepfather and mother were found. We believe it's them. They now have been positively identified as his stepfather and mother were found deceased, shot. The stepfather was shot in the back of the head, and the mother had 3 gunshot wounds, one close up to the neck, and then 2 others that were non-fatal. Obviously, a dead person cannot give consent. We believe that the date of violation, although it's not in here, the date of death is on or about February 11th, 2025, which means that the defendant was living in the house with his deceased mother and stepfather for a period of time up to February 23rd, based upon the fact that and I believe that there was a neighbor who said that I don't even think the defendant had a driver's license to be able to drive a car. So based upon that and the fact that he was underage, I believe the inference is that he did not have consent to either take the firearm out of the house or the car. Obviously, the person that would have had to give him consent is dead, and we believe forthcoming charges will be brought accusing this defendant of causing that death. So at least for this hearing, we do believe that the motion should be denied. The 4 corners of the complaint adequately established probable cause to believe a crime has been committed and that the defendant committed that crime.
What you just heard there was new information when it comes to this timeline that prosecutors have. They say that Nikita's stepdad and mom were killed on February 11th. Their bodies not found until the 28th, and prosecutors say they believe Nikita lived in that house until February 23rd, nearly 2 weeks. I want to go back to something also that was noted in the criminal complaint related to text messages that Don Meyer allegedly sent family and even his boss at work. Deputies say that Don's sister received a text on February 18th, which is 7 days after prosecutors believe he died, saying that he had been sick and he was going to take some time off social media. His family also said that he had sent text messages that they found weird on February 23rd, also after the day that authorities believed that Don Meyer died. The complaint also shows that Meyer's manager at work said that they were in text communication from February 13th through the 25th, saying that he was sick and he couldn't talk on the phone. All these dates after when prosecutors say Don Meyer and Nikita Casap were killed. The judge denied the defense's motion to dismiss this case, and the hearing then moves on to bail. Here's what the prosecution had to say.
Since this complaint has been issued, we certainly have much more information. We have downloads of electronics. We have downloads from applications that the defendant was using, and certainly the defendant will be charged with 2 counts of first-degree intentional homicide in the very near future. I'm just waiting for a couple of warrants to come back. Further, the defendant was communicating via an app in either Russian or Romanian. We're not sure. The FBI is helping us to translate those communications. I can tell the court the defendant had $14,000 in cash on his person. He also stopped at least 1 Bitcoin machine and made 12 different transactions through that machine. That is not money that you get, but it goes into a wallet that he presumably has access to. We are asking for $250,000 cash bail, that he be ordered not to leave the state of Wisconsin. He not use or possess any type of dangerous weapon. The defendant was born in Moldova. He came to the United States approximately 10 years ago with his mom. The allegations again involved the defendant leaving the residence, last seen at the residence on February 23rd. The last time either the victim A or victim B was seen alive would be February 11th. I believe he stopped attending school on February 12th. We do believe that the 2 victims were killed on February 11th. The defendant continued to live in that residence with the 2 bodies in the house. He then fled with the $14,000 in cash. We know that he was communicating with someone indicating that he had the name of a person to get fake plates from to put on the car in order to obviously hide the fact that the car was stolen. We know victim A and victim B both had injuries consistent with gunshot wounds, as I described before. The stepfather had a contact or near contact wound to the back of his head, and his mother, victim B, had wounds to her torso, as well as we believe a close gunshot to the neck, which would have been the fatal gunshot. He has no family in Wisconsin. His maternal grandmother lives outside the United States. He does have, through his stepfather, he has family. Victim A has family in Massachusetts. I don't think at this time that they're too interested in this defendant. We do know, like I said, he was communicating in Russian or Romanian. We are trying to work through that with the FBI. We also know that based upon the fact that the defendant had both victim A and victim B's driver's license, as well as other identifying information for his parents, or for his stepfather and his mother, that we don't know what he intended to do with that identification. But we do believe he is a risk not to appear in the future. As indicated, I will be issuing additional charges hopefully in the next week, and they will certainly be more serious, involving the death of victim A and victim B. For all those reasons, Your Honor, the state does believe he is a risk, and we'd ask the court minimally to do the $100,000 that Judge Boren felt was appropriate, but based upon the information we now have, including the lengths that the defendant was willing to go to conceal the car and possibly conceal his appearance by bringing cash and getting Bitcoin, the state does believe the $250,000 cash bail is appropriate.
Prosecutors say that Casap had not only a gun on him, but also $14,000 cash, and he went to a Bitcoin machine as he allegedly fled. He was also allegedly in touch with someone to switch out his stepdad's car plates. And lastly, the FBI is now involved in this case, trying to figure out who Casap was allegedly communicating with online in either Russian or Romanian. Here's what the defense argued when it came to bail. The judge sided with the prosecution, and Casap is being held on $250,000 bail, with murder charges expected in the next week. Join us now to break down this case further is defense attorney and former prosecutor Safa Robinson Ferrer. Thank you for taking the time to be with us here on Law and Crime. I want to start first after seeing him back in Wisconsin, the suspect Nikita Casap. It seems like there's a lot of evidence, and yet he's still not facing murder charges right now, even though the prosecution says that that's going to happen in the very near future. What do you make of the fact that he still, though, is only being charged at this point with stealing a car and then possessing that firearm?
What it tells me is that the prosecution is trying to conduct a thorough investigation before they bring about these additional charges. One of the most important things as a prosecutor you want to make sure you're doing is you're adequately and accurately charging the individual. So you don't want to overcharge them with evidence that you can't prove at a trial, but also you don't want to undercharge the individual. Now here we can expect that there are going to be some murder charges that are added. Statutorily, which murder charges or which homicide offenses will he be charged with? We don't know that at this point, but what I think the prosecutor is trying to do is just ensure that she has enough evidence and information as she adds these additional charges to make sure that everything that she is charging is sufficient and appropriate.
How does that work where he was found with a gun that is presumed to be the murder weapon, and it feels like there are just cases, and this is where you can tell me I'm wrong because you're the attorney and I'm not, but it feels like there's some, like, people get charged with murder for a lot less evidence at times. Why not charge him with murder and then add those additional pieces of evidence later? Is that something that they can do, or is it just not how that works?
That is something that they can do. I don't know why the prosecutor took this position with respect to this case. It seems that during the arraignment for these charges, that the prosecutor had enough information to indicate that the murder charges would be forthcoming, and she added information in the opposition of the bail application to indicate and reflect that he was responsible for those murders, or he's alleged to be responsible for those murders. So I can't say for certain why she would have waited. I expect that they're going to have a preliminary hearing within 9 to 10 days, and so it's expected that she's going to file them or amend the complaint against him to add those additional charges once that time comes. I do believe that they're getting search warrants for phones and devices and things like that. or that they have done that. And so I expect that that information will solidify and confirm, what charges she's looking to go forward with. And it could have just been a matter of timing. Sometimes what happens is, with respect to, charges and evidence that prosecutors have at the moment, whatever they find necessary to establish at least some basics of a charge, they will use that to go forward and at least get the individual held in custody, and then add those additional charges later.
How common is it to, in court, say that this person is eventually going to be charged with a more serious crime and try to factor that into whether they would be held on a higher bail, even though at this point he has not been charged with murder?
Yeah, so of course the prosecution is going to try to do that, and I see both sides of the coin here. If there's evidence that is sufficient to prove or show that he is alleged to commit the homicides, you don't want to risk him getting out and reoffending and murdering somebody else. So that's the most important thing, is protecting the public. But at the same time, there is an argument to be made that he is not charged with the murders, and I think that his defense attorney made these arguments during their bail application and during the arraignment, but he has not been charged with the murder. At this point in time, he's simply charged with stealing or using the motor vehicle, or unauthorized use of the motor vehicle, and for having that firearm. And so those are the charges that they have now. How fair is it to, set such a high bail and treat this individual as if he has been charged with murder when he has not? There's arguments to be made on both sides, but I think the interest of the public is why the prosecutor made those arguments for such a high bail, referenced the homicides, and why the judge went along with setting that $250,000 bail.
And in your experience, being both a criminal defense attorney and a former prosecutor, how much of that is on the judge and just the particular judge that you get, and how they typically handle those proceedings?
It certainly does depend on the judge that you get. You get some judges that are more liberal, some judges that are more defense friendly. You get some judges that are more conservative. And one of the things that the judges will always consider is, if I let this person out and this person commits another homicide or some other alleged act of violence, this is going to come back on me. So as the judge looking at this, they're saying for themselves, in order to protect the interests of the public, the integrity of the case, and not only that, but to cover my back as the judge, I'm going to go along with this high bail. And judges will do that. Some judges who are more defense friendly or more liberal may say, you know what? He's not charged with the murder right now. If you were that concerned about it, prosecution, you should have had him charged with that by this morning. And so I'm going to go along with the lesser bail, or entertain his release to some extent, whether that's monetary, on a monetary basis, or electronic monitoring.
Safa, what do you make of the defense trying to just dismiss this case? Because I did read through the criminal complaint, and it was a neighbor that saw him driving the car. He doesn't have a license. And then he's arrested in Kansas with the vehicle. But the facts of the matter are, his stepdad has passed away. So it's, by looking at a criminal complaint, unclear whether or not he was given permission. What do you make of the defense of trying to get this case dismissed altogether?
The defense attorney did exactly what she should have done and what she was supposed to have done. One of the things that's important is, the accusatory instrument that's filed in court, and that's a charging document for the defendant. It alleges that the defendant committed X, Y, Z. One of the things that happens is there's a four corners challenge, which essentially says, judge, we're challenging what is written within the four corners of this accusatory instrument, because based on our position and our belief and review of this accusatory instrument, there is not a sufficient basis to charge this individual with this crime. His attorney during the arraignment noted that the consent factor is in question. There's nothing to indicate that the deceased or the decedent did not consent to the use of the firearm, or to taking of the firearm or the vehicle. And so that's one of the things that should be challenged in the legal world, or in the legal realm of this. One of the things the prosecutor has to show is that he did not have consent. Now, the court, in reviewing the four corners of the accusatory instrument, can infer that consent was not had. But later down the line, that inference and that standard at the arraignment is not going to be the same when it gets time to a trial and the prosecutor has to prove lack of consent beyond a reasonable doubt. The defense attorney did what she should have done in this case. There was a great argument against the prosecution indicating that there's no proof of the lack of consent. The individuals, unfortunately, aren't able to consent or not consent. And so that was the argument that was made. I think there's a good point to be made there, but the judge determined that based on his ability to infer, he was going to maintain that the accusatory would stand.
And to your point, like kind of seeing both sides of it, just because as someone who's not a lawyer, just kind of watching this case, a member of the public, anybody who would be accused, even in the court of public opinion, of committing murder this way, you wouldn't want them out on the streets. But then from the other side, I do see the defense saying there's nothing in here that shows that he actually stole the car. Who knows if the stepdad said, take the vehicle, go for it, drive to Kansas, and then someone else came into the home and did it. That argument could actually hold some water. I guess I could see that if you were a defense attorney, you feel like you're fighting an uphill battle because of these charges that haven't even been filed yet for a much more serious case.
Yeah, most definitely. And so that's a question. And I give credit to the prosecution as well, because of course you can infer, well, they weren't able to consent because they weren't alive. But again, those things have to be proven beyond a reasonable doubt later down the line. Now, I expect that once the murder charges come in, these charges that he was arraigned on as of yesterday are going to be the least of his problems. So we'll see how things unfold as things proceed. We'll see if this case ultimately ends up at a trial. The prosecution will have a higher burden at that point, higher than they did here at the arraignment and at the preliminary hearing that's coming soon. But I expect that the murder charges are going to be much more significant, and that's going to be the driving force behind this case.
And from what we know that's been put out in the public, we have this criminal complaint that was put out. And then I noticed in this hearing that we just watched, the prosecution kind of had some nuggets of information in their pocket to respond to the dismissal argument. Like he had been in touch with someone apparently to get different plates for the vehicle to switch those out. He was communicating with someone through an app that the FBI is looking at that was either in a Russian, Romanian, Eastern European language. He is from Moldova originally, and he had $14,000 in cash. As a prosecutor, you're coming into these hearings. Are you keeping that information just in your back pocket in case you have to use it, in case the defense in this case makes that four corners argument like they did?
Absolutely. And regardless of whether they would have made that four corners argument or not, that is certainly information that I would have used and should be used at a bail hearing, because that's technically what this is the arraignment and then an argument for bail. Those key pieces of information show what we call consciousness of guilt, and essentially fleeing the area, looking to have places to conceal, having large sums of money, communicating with someone in another language. And essentially the idea is that he could have and may have had the idea to flee the country, shows that he is a risk of flight. So from a prosecutor's standpoint, he's a risk of flight. He will not return if he's let out on bail or if he's released on his own recognizance or something of that nature. Not only that, but I'm also arguing that he is a threat to the public, considering that these homicide charges are forthcoming, and it's our position that he allegedly murdered his mother and his stepfather.
$250,000 cash bail is what he was held at. The defense was arguing at most $100,000. The judge ends up going with what the prosecution was calling for. What do you make of that decision?
I think that in that instance, for the judge to go with the $250,000 bail reflects his opinion that he's not inclined to allow this individual to simply be released. And again, this is a higher bail. There are allegations here, and again, he hasn't been charged yet, but that he allegedly committed a homicide or two homicides, and he has connections out of the country. So he is a risk of flight. He is a possible threat to the community in the eyes of the prosecution, and it appears that the judge viewed things that way as well. I think that he may, prior to the arraignment, have been held on a $100,000 bail, but the judge found it more sufficient for a $250,000 bail because he does not know the access of what this young man might have. And we've seen in other cases before, or as cases that are currently pending, some people will, donate to bail bail fees and things like that for defendants. And so one of the things that the judge wants to ensure is that there is a high bail. The reasoning for bail is to ensure that an individual comes back to court, but also we all know that if there is a higher bail, it's at least less likelihood that the person will be able to post that bail and they're going to be sitting there. And that's ultimately the intention for that high bail.
Yeah. And with the prosecution saying that first-degree murder charges are expected in the, quote, very near future, this entire conversation about a stolen vehicle and a gun may, to your point, be the least of his concerns. Also, it'll be interesting when the FBI is able to piece together the communication he was having with someone in Russian or Romanian. If he had plans to somehow get to Eastern Europe, I don't know how he would have been able to do that. But there's kind of like all these details that started to come out. If you're the defense, what's your approach in this case? Because it does seem, at least from what we know publicly, that there's a lot of things that connect him to what happened in this house to his stepdad and his mom.
With the approach that we take as the defense is first conducting our own investigation. This is first we need to assess the whodunit. Yes, there may be evidence pointing to, or it doesn't look that great for us that, my client may have fled from the area and all of these things occurred. But what happened prior to that? Was there anybody else at the home? Were there any other visitors? Was there anybody else involved in this that could negate my client's guilt with respect to this? That's the first things first. Second thing we go to is, okay, if we know that something occurred, why did this occur? Is there some sort of mental health implication? People don't just wake up and decide to kill their parents, although that has happened frequently enough. But why did this occur? Was there some sort of abuse that had been taking place during this time? And that might be a direction that we need to explore and ultimately may take as well. But also creating doubt. At the end of the day, it's the prosecution's burden to prove the defendant's guilt beyond a reasonable doubt. And if there is any sort of doubt with respect to any offense of any of the crimes charged, then the jury at a trial must find the defendant not guilty. And so we attack those key pieces of evidence. Just because we're sitting here now talking about the charges and the evidence that we know of that exists doesn't mean that all of that evidence is going to come in as proof. Yes, many of us may think that he's guilty, but of course he's not guilty at this point because he hasn't been adjudicated at a trial as guilty by a jury. So we have to keep all of those things in mind, attack the key pieces of evidence, attack the search warrants and things of that, and also ensure that, there isn't anybody else that isn't involved that could possibly be the reason or responsible for the deaths as well.
Saf, the final question is just about his age. He is 17 years old, so he is a minor, yet he's being charged as an adult. We often see this happen. Why is that?
I think that happened and has been happening quite often. He's on the brink of being 18. That's first things first. And although he is technically still a minor, under the state of Wisconsin, they have the ability to charge him as an adult. I think that when we see crimes that are so heinous, such as this one, or allegations that are so heinous, such as this one, prosecutors want to ensure that if the person is near to the age of 18, that they are charged in accordance with that, because at that point, you should know, you shouldn't be killing your parents or anything like that. And we're going to treat you as such, that you had some level of knowledge or skill or the mental capacity to know what you were doing. Although you may have been 17, you have an adult-like capacity to know what you were doing at that time. And again, the heinousness of the crime, the killing of your parents, the manner in which these things were done are all things that the prosecutor is going to consider when determining whether or not to charge someone of his age as an adult. And I think we're going to be seeing that more and more as things continue to play out, in crimes that are alleged to have, been double homicides and more, or cases that are just so gruesome and heinous that, the prosecution's never going to want these people to see the light of day again.
Yeah, and we'll see what happens as this case continues. He is expected to be back in court a short time from now. And according to the prosecution, will be facing murder charges in the very near future. Safa Robinson-Ferrer, always great to have you on Law and Crime. Thanks for taking the time to be with us.
Thank you for having me.
Nikita Casap is expected in court next on March 24th, where it's expected he will enter a plea. For On the Case, presented by Law and Crime, I'm Chris Stewart. We'll see you next time.